A county clerk in rural Montana pulls a routine deed transfer across her desk. Standard paperwork. She stamps it, files it, moves on. 3 days later, her supervisor calls her into the office. He slides the document back across the desk and points to the signature line. She looks down. The name on that signature, the woman who supposedly signed this property over, has been legally dead for 9 years. The clerk stares at the paper. The signature is not forged. It is a perfect verified match. The dead don't sign documents, so either the courts got it wrong or someone made very sure they would. What you are about to hear is the story of a woman who vanished, a man who profited from her disappearance, and the single stroke of a pen that brought 9 years of carefully constructed silence crashing down. Stay with me, because nothing about this story is what it first appears to be. Within 48 hours of that signature discovery, 3 things happen in rapid succession. A probate attorney in Ohio receives a subpoena. A man who inherited a $2.3 million estate, a man who stood at a memorial service, who delivered a eulogy, who accepted condolences from friends and colleagues and neighbors goes completely unreachable, and a woman using a different name, in a different state, quietly stops showing up to work. We don't know yet who these people are to each other. We don't know what the estate contained, or how it was built, or what it cost the people whose names were on the paperwork. What we do know is this. Somewhere between a death certificate filed in 2015 and a deed transfer filed in 2024, someone committed one of the most calculated frauds a family can endure. And the only reason any of it unraveled is because of a county clerk who almost didn't look twice. By the end of this video, you will understand exactly how someone that trusted could do something that unforgivable, and how a single signature on a single piece of paper tore open 9 years of lies. There are 4 people at the center of this story. A wife declared dead, her estate divided, her memory eulogized. A husband, the grieving widower who inherited everything and moved on faster than most people thought was decent. A stepdaughter estranged, ignored, and dismissed every time she raised her hand and said something is wrong. And a woman living quietly in Montana under a name that does not belong to her. 3 questions are going to drive everything you're about to hear. Was this woman actually declared dead through honest legal process, or was that declaration something that was engineered? If she was alive this entire time, why did she disappear? And who stood to gain the most from everyone believing she was gone? There are 3 moments in this story that changed everything. The first happened before anyone even knew to look. The second happened in a courtroom where no one asked the questions that needed asking. And the third is that signature. We start before the death certificate. We start where they wanted you to believe the story ended. Margaret Calloway was the kind of woman her neighbors remembered in specific, vivid detail. Not in vague, polite terms, the way people sometimes speak about the dead. In specific ones. The way she kept a handwritten grocery list even though she could have used her phone. The way she returned borrowed things with something extra tucked alongside them, a jar of jam, a paperback she thought you might like. The way she remembered the names of people's children and their pets and their mother's health conditions. She was meticulous without being cold, organized without being rigid. The kind of person whose presence you noticed most clearly in the moments after she left the room. She had grown up in central Ohio, the middle daughter of a school teacher and a postal worker. She was the first in her family to finish a 4-year degree, studying accounting at Ohio State, and she took that seriousness with her into every corner of her adult life. By her mid-30s, she was working as a senior bookkeeper for a regional property management company, a job that required precision, discretion, and an eye for discrepancies that most people would miss. She was good at the work, exceptionally good, the kind of good that makes certain kinds of people uncomfortable. She met Daniel Hargrove at a professional conference in Columbus in the late 1990s. He was a property consultant, a man who understood land the way Margaret understood numbers. He was self-assured without being arrogant, or at least that was how it appeared at the beginning. He had a daughter from a previous relationship, a girl named Claire who was 10 years old at the time, and the fact that he was a devoted father was something Margaret noted early and held on to for a long time. They married in 2001. By the standards of the people around them, it looked like a solid union. They bought a home in a suburb of Columbus. They acquired 3 rental properties over the next decade. They built a joint investment portfolio that grew quietly and steadily through careful management and Daniel's eye for undervalued land. Claire, Daniel's daughter, was never quite at the center of that household, and she knew it. She was welcomed. She had her own room. Margaret treated her with genuine warmth, the kind that cannot be faked for long periods around children, and Claire adored her for it. What was more complicated was her relationship with her father, a man who, she would later say, had a way of making you feel like your value to him was something that could be quietly reassessed without notice. Claire moved to Portland in her mid-20s. She and Margaret stayed close through texts and occasional visits. The last message Margaret ever sent her was about a soup recipe. Claire still has it on her phone. In the spring of 2013, something began to shift. Margaret's sister, Linda, received a phone call that she would describe to investigators years later as the one she replayed more than any other. Margaret's voice was different, not distressed in a way Linda could point to. Flat was the word she kept coming back to, careful, like someone choosing each word with attention to what it was not saying. Linda asked if everything was all right. Margaret said she was fine. Linda pressed. Margaret said only this, "I just need you to trust that I know what I'm doing." 6 weeks later, Margaret Calloway was reported missing. 8 months after that, a preliminary missing persons file was opened and quietly classified as a voluntary disappearance. And 4 years after that, she was declared legally dead. Daniel's account to police in the weeks after Margaret's disappearance was, by all reports, calm, detailed, consistent in the way that only practiced accounts tend to be. Margaret had been struggling, he said. He used that word carefully, and he used it often. With what, exactly? He was reluctant to specify depression, he thought. A vague withdrawal that had been building for months. One morning he woke up, and her car was gone. Her purse was still on the kitchen counter. Her phone was plugged in beside the bed. He had assumed she had gone for an early walk. By noon, he knew something was wrong. Police initially treated the disappearance as voluntary. There was no sign of physical violence, no evidence of a struggle. Margaret was an adult woman with no documented history of mental illness and no criminal record. Adults leave sometimes. The detective assigned to the case, a man named Roy Decker, opened the file, followed the standard investigative threads, and found nothing that demanded a different classification. What did not make the initial reports, what would only surface years later during a forensic financial review, was that Margaret's share of a joint banking account had been moved 11 days before she disappeared. All of it, transferred into a joint holdings account and then out again within 72 hours. Daniel, when asked about it later, said Margaret had asked him to handle a portfolio consolidation. He produced the paperwork. He always produced paperwork. Claire called Detective Decker 3 times in the first month. She told him that her stepmother was not a woman who walked away from things. That Margaret was precise, loyal, and deeply connected to her life in ways that a voluntary disappearance did not account for. Decker listened. He noted her concerns. The file remained classified as it was. By the end of the following year, Margaret's case had been effectively suspended. Roy Decker would later say, in an interview that took place long after any of this mattered for the original investigation, that the thing which stayed with him was not what he found, but what he did not think to look for. In 2019, Daniel's attorney filed a petition in an Ohio probate court to have Margaret Calloway declared legally dead. In most American states, a person who has been absent for 5 or more years, with no evidence of life, can be legally declared deceased under the presumption of death statute. The petition was supported by a package of documentation, signed affidavits from 2 individuals attesting to Margaret's long history of emotional instability, a letter from a psychiatrist who had seen her on exactly 2 occasions, and a timeline of the marriage that characterized its final years as increasingly troubled. The court approved the petition in 11 weeks. That is not slow for this kind of proceeding. It is, in fact, unusually fast. Claire contested it. She hired an attorney of her own and filed a formal objection, arguing that Margaret's disappearance had never been properly investigated, that no remains had been found, and that her father stood to inherit an estate now valued at over $2.5 million if the declaration went through. The court reviewed her objection and found her concerns, in the language of the ruling, speculative and insufficient to warrant delay of the proceeding. Daniel Hargrove was declared the sole heir to the estate of Margaret Calloway. He liquidated 2 of the 3 rental properties within the following 18 months. He moved the proceeds into a private investment account. He did not remarry. He did, however, begin a relationship with a woman from his professional network that his colleagues described as serious. Meanwhile, roughly 1,800 miles away, a woman named Ruth Elaine Marsh had been quietly building a life in a small community outside Billings, Montana. She arrived in 2016, a year after the death certificate was filed. She rented a room at first, then a small house on the eastern edge of town. She paid cash for most things. She worked part-time at a local plant nursery and was known there as careful with her hands, precise in her work, warm in a way that kept people at a comfortable distance. She had no credit history, no presence on social media, no visible family, no story. In the way that most people have stories, the small accumulated details of a life that other people can corroborate. The people who knew her liked her. The people who liked her knew almost nothing about her. In 2023, Ruth Elaine Marsh made a decision that would undo everything. She purchased a small property, 1.4 acres, and a modest structure on the outskirts of town using a combination of cash savings and a private seller financing agreement. The deed was prepared, signed, notarized, and filed with the county. It was routine paperwork. It moved through the system the way routine paperwork does. And it sat in a filing cabinet for 11 months before a supervisor pulled it out and asked a county clerk to explain why the name on the signature line matched a woman listed as deceased in the Ohio State Death Registry. What happened to Margaret Calloway did not happen in a single moment. It happened in a sequence of small, deliberate moves that, taken individually, each had an innocent explanation. That is the thing about this kind of situation that is hardest to understand from the outside the architecture of it. The way each piece was constructed to be deniable on its own, while being devastating in aggregate. The forensic financial reconstruction, which was conducted after the deed discovery triggered a joint investigation, begins in 2012. That is 3 years before Margaret disappeared. In that year, there are a series of property valuations across the joint portfolio that consistently and significantly underreport Margaret's ownership share. There is an insurance policy restructuring that removes her as a primary beneficiary. Margaret signed the change form. Whether she understood what she was signing or whether she was told it was something routine, something administrative is something that cannot now be established with certainty. But it is a question the investigators asked more than once. By 2013, Margaret's direct access to the joint accounts had been reduced in a way that was gradual enough to avoid alarm, not eliminated, reduced. The change happened across several transactions over the course of 8 months, each one small enough to be explained away as a bookkeeping adjustment or a portfolio restructuring. Margaret was an accountant. She would have understood, eventually, what she was looking at. And investigators believe that is exactly what happened in the final weeks before she left, that Margaret found something. A statement, a valuation, a document that made a pattern visible that she had not seen clearly before. And rather than confront it directly, she made a decision that no one in her life anticipated. She ran, not impulsively, not in despair, deliberately, methodically, in a way that suggested she had been thinking about it for longer than anyone knew. She did not take her purse. She did not take her phone. She left behind every traceable thing because she understood, with the precision of someone who had spent years working with financial documents, that a woman who wanted to disappear completely could not afford to carry her own identity with her. She had been frightened, not of what had already happened to her, but of what she believed was coming. And she disappeared so thoroughly that even the people who cared about her, who looked for her, who refused to accept the official explanation, could not find her, because she did not want to be found. Not yet. Not until she felt safe. What she did not know, what no one told her, because no one could, was that while she was building a quiet life in Montana under a borrowed name, the man she had left behind was in an Ohio courtroom having her declared legally dead. She did not know that the estate she had spent 2 decades helping to build had been transferred entirely into his name. She did not know that the affidavits supporting the petition had been signed by 2 men with documented financial relationships to Daniel's consulting firm, or that the psychiatrist whose letter described her as unstable was a college acquaintance of Daniel's who had seen her twice in a professional context and never treated her for anything. She knew none of this. She was in Montana, paying cash for groceries, working with plants, and believing that the hardest part was already behind her. And that is when everything they thought they knew collapsed. The deed discovery in the county clerk's office triggers a notification to the Montana Department of Justice, which in turn contacts the Ohio Bureau of Criminal Investigation. The connection between Ruth Elaine Marsh and the deceased Margaret Calloway is treated initially as a clerical anomaly, a name similarity, a possible data entry error, the kind of administrative confusion that happens more than most people realize when death records cross state lines. But within 72 hours, a forensic handwriting examiner has compared the signature on the Montana deed to Margaret Calloway's signature on a 2013 Ohio property closing document, and the match probability is 99.3%. A second independent examiner is brought in. The result is the same. Investigators run Ruth Elaine Marsh's identity documents through federal databases and find what they expected to find: a paper trail that leads nowhere real. The Social Security number attached to the name belongs to a woman who died in 1987. The birth certificate was generated through a low-cost document preparation service operating across 3 states, the kind of operation that exists in the margins of the legal economy and that law enforcement has been aware of for years without the resources to shut it down entirely. Ruth Elaine Marsh was a construction, assembled piece by piece by someone who knew what she was doing and had the patience to do it carefully. Daniel Hargrove, when reached by Ohio investigators, issues a statement through his attorney. He has no knowledge of the Montana deed. He has no knowledge of any woman named Ruth Elaine Marsh. He is, as far as he understands, the sole heir to the estate of his deceased wife, Margaret Calloway, and any suggestion otherwise represents an attempt to relitigate a matter that was settled by the courts. He is unreachable for follow-up questions. His attorney advises that all further communication go through the firm. Claire receives a call from an investigator in the second week of the inquiry. She listens to what he tells her. When he finishes, there is a long pause, and then she says, "I told them." 3 words. No anger in it by that point, just the exhaustion of someone who has been saying the same thing for years to people who were not listening. Before we go further, and we are about to get to the part that answers the question this entire story has been building toward, I want to take a moment and ask, where are you watching from? Drop your city or your country in the comments below. We genuinely love hearing from the people who find these stories. And if you have not subscribed yet, now is a good time, so you do not miss what is coming on this channel. Margaret Calloway is alive. She consents to identification. In a recorded interview conducted by Montana investigators at a location that has not been made public, she confirms her identity, her history, and the sequence of events that led her to a small property outside Billings under a name that was not hers. She is composed. She speaks carefully, the way people speak when they have been living with the weight of a secret for nearly a decade and have thought many times about what it would feel like to finally set it down. She describes what she found in the spring of 2013, a set of financial documents she had not been shown, a valuation report that had been prepared without her knowledge, a pattern of transfers she recognized immediately because she was the one who was supposed to be managing the accounts. She describes the feeling of understanding arriving not as a sudden shock, but as a slow, terrible clarification of things she had already sensed for months. She describes the conversation she did not have with Daniel, the one she started rehearsing in her head and then stopped, because something in the calculation of his behavior told her that having it would be a mistake. She describes driving away in the early hours of a March morning with a small amount of cash she had been setting aside in increments for 8 months, and the understanding that she was not coming back. When investigators tell her about the death declaration that Daniel had filed the petition 4 years after she left, that an Ohio court had granted it, that the estate had been transferred entirely into his name, she is silent for a long time. Then she says, "Of course he did." Here is what the investigation then uncovered that Margaret did not know. Daniel Hargrove did not act alone. The 2 men who signed affidavits attesting to Margaret's long history of emotional instability had been clients of Daniel's consulting firm for 11 and 14 years, respectively. The psychiatrist who provided the supporting letter had attended the same university as Daniel and had maintained an informal professional relationship with him for more than 2 decades. And the probate attorney who filed the petition had been quietly purchasing distressed properties from Daniel's estate portfolio at below market value across a 3-year period ending 8 months before the petition was filed. This is the moment this story shifts from the tragedy of a woman who felt she had no option but to disappear into something with a different shape entirely. Because what the evidence suggests is not a grieving husband who moved on and made pragmatic legal decisions. What it suggests is a network small, informal, built on long-standing relationships and mutual benefit that was activated at precisely the moment it needed to be. The death declaration was not the end of what Daniel Hargrove built. It was the mechanism by which he completed it. And now return, for a moment, to that county clerk in rural Montana, the one who pulled the routine deed transfer across her desk, stamped it, filed it, and moved on. The one whose supervisor called her in 3 days later and slid it back. She later told an investigator that she had almost not flagged it, that it was a routine transfer, clean paperwork, nothing out of order on its face. What made her stop was something she could not fully explain, even afterward, a name that struck a faint, distant chord. She had seen it somewhere, she thought, months earlier, on a missing persons notice in an old community board at the local library, the kind of board covered in photocopied flyers that most people walk past without stopping. A face she had registered without knowing she registered it, and something about the signature on that deed made her pause long enough to remember it. 9 years of silence. $2.5 million in transferred assets, a death certificate, a eulogy, a legal proceeding, all of it undone because one woman's instinct told her to stop and look again. Margaret's legal death declaration was formally vacated by an Ohio court following the Montana investigation. Civil proceedings against Daniel Hargrove and 2 of the individuals connected to the petition are ongoing at the time this video was produced. A criminal referral has been made to the Ohio Attorney General's office. No criminal charges have been filed as of the date of this recording. The estate remains the subject of active litigation. The property in Montana, the 1.4 acres that Ruth Elaine Marsh purchased with nearly a decade of cash wages, belongs, legally, to Margaret Calloway. Claire and Margaret have spoken. What passed between them is their own. Margaret has not returned to Ohio. There is a version of this story that ends with a verdict, a sentence, a number attached to what was taken. That version has not arrived yet. What has arrived is the record, the forensic trail, the match signature, the network of relationships mapped by investigators who now know what to look for. And the question that Margaret's case leaves behind is not whether she was right to run. It is why running felt like the only available option. Why a woman with a 4-year accounting degree, a professional career, and 2 decades of documented financial contribution to a shared estate felt that the safest thing she could do was erase herself. That is not a question a verdict answers. It is the question underneath the whole story, and it is the one that will sit with you longest after this video ends. Here's what I want you to think about and leave in the comments. Margaret spent 8 months quietly setting aside small amounts of cash before she left. She did not make one dramatic move. She made dozens of invisible ones. At what point do you think the people around her, her sister, her stepdaughter, her colleagues, could have seen what was happening? And what would it have taken for them to do something about it? Tell me your answer below. I read every single comment on this channel, and this is exactly the kind of question this community handles better than anywhere else. If the kind of storytelling you just spent the last 30 minutes with is what you come here for, cases that go past the headline, stories where the real thing that happened takes years to surface, then subscribing means you will be here when the next one drops. And the next one is coming very soon. Next video. A man discovered he had been legally removed from the deed of his own home while he was still living in it. Somebody filed a single document, and by the time he found out, the house had already been sold twice.